let's try and here's some moderately good news. Okay, so moderate, but anything helps these days. You'll recall that many times in the past we've interviewed people about SEC enforcement actions. And we have seen time and time again that even when the SEC brings an investment bank to court, files criminal charges, civil charges, seeking fines, never a jail term, more often than not, in fact, almost always, the company charged with this violation did not have to admit that they were wrong as part of any type of settlement. Now, as you know, I co-host Ring of Fire on the weekends with Mike Papantonio, who is a plaintiff's lawyer or a tort lawyer, trial lawyer. And much of what his firm does, or at least part of it, is these type of securities trials. This change by the SEC that I'm about to discuss is going to have huge implications in terms of abilities of cities, public institutions, large pension funds to bring cases against these investment banks that have defrauded them going forward. Because of pressure from people like Elizabeth Warren and because of judges who have sort of been fed up with having to sign off on deals wherein these defendants, whether it's Citigroup or JP Morgan, don't have to admit wrongdoing, SEC Chairwoman Mary Jo White announced a significant change in policy. And we talked about Mary Jo White, and she got some plaudits from certain circles. Now, this isn't huge, but this is important. For certain violations, I'm not clear on which, the agency would no longer allow financial institutions to simply pay a fine without admitting wrongdoing. In its latest cases, the SEC has been following through, demanding an admission of guilt from JP Morgan in the case of the London Whale and extracting one from hedge fund advisor Philip Falcone. This has relevance for many reasons. One, of course, is symbolism. It's rather important that somebody admit that they actually committed a civil or criminal violation. Subsequent litigation is the big issue here. You will see class action lawsuits from investors who are taken by these actions, and it will be much easier for them to prove and win these cases because the defendant in these cases has already admitted guilt and wrongdoing, and in those cases the bar to admitting guilt is actually higher than it would be in the course of a tort action. It will mean that as you start to rack up these settlements, it'll no longer be, well, we just settled, it was no big deal. Alongside that will be an admission that you had done something wrong. So it's going to impact you in the marketplace to some degree, theoretically. It could implicate your banking license going forward. So no longer are we going to have situations where financial institutions can go back and repeatedly break the law time and time again and say, look, my record is clean. I haven't committed any wrongdoing. And in some instances, apparently, you're not eligible to provide services in situations if you have been found guilty or accepted guilt in wrongdoing of any certain violations. So and apparently one of the big benefits is also tax revenue. When you don't admit guilt as a company, you're allowed to write off your defense. When you do, you cannot get a tax deduction for what you spend defending yourself.
We're going to need to write off that whole, like, the frauding the old lady thing. Not anymore.
Not
we
just
did
that.
wrong.
But it's not just that, because it also means that the financial calculation is going to be different. They're not going to fight these things for years if they know at the end they're not going to just get an easy out by paying off a fine. Now, it really is a function of what the violations are, but there's your moment of slight optimism. It's a grain of sugar in a sea of some other granular stuff that's more bitter tasting than sugar.